Good afternoon, Madam Chairman, distinguished ladies and gentlemen, dear friends. I'd like to start with hellos from Poland, and of course thank you. Thank you for the invitation, for the possibility for this interesting experience, especially for me, specializing in the border between constitutional and private law. One could say that it's obvious that we should cooperate, that we should collaborate here in our countries between Mediterranean, Black Sea and Baltic Sea, and it's of course desired, relevant, and our cooperation should be deepened. But somebody must organize it, must help in this cooperation, and in my opinion, Ferenc Mádl Institute does it perfectly. So congratulations on this start, on this energy, and I keep finger crossed, not to football and today's match with Hungarian and Polish teams, but also for the future next activities and successes. Going to my presentation, I'd like to show you the main effects, also some general information. If you could please confirm if you can see this presentation. So I'd like to start with some general remarks about the idea of constitutional court in Poland, the evolution of competences, status and judges. It can be usable, this link to translation of our constitution published at parliamentary website. We are also proud of the written constitution in the world, issued in 1791. Now we are minded with the constitution of 1997, and the idea of constitutional court was a part of postulates Solidarność movement in 80s. Then since 1982, the first functioning in reality, next bills, next status amendments, and finally the constitution regulates details of functioning of Polish constitutional tribunal, and in detail, this is a detailed regulation. What are the competences? You can see Polish Constitutional Tribunal, the wide scope of competences, of powers, shall adjudicate conformity of statutes and international agreements to the Polish Constitution, the same with the relation between international agreements and statutes, the same with legal provisions issued by central state organs, and then the conformity to the Constitution of the purposes of activities of political parties. This is a kind of political competence. Then complaints concerning constitutional infringements, individual complaints, and also disputes over competences of authorities, of state authorities, especially in the cases of positive conflict of competences between central constitutional state bodies. Who may apply many subjects, starting from the President of Poland, Marshal of Parliament, Prime Minister, also 50 deputies to lower instance of Parliament, Sejm, or 30 senators, also the first presidents of Supreme Court, Administrative Court, the Prosecutor General, and the President of the Supreme Chamber of Control, as well as the Commissioner for Citizens' Rights. In limited scope, in matters connected with their activity, also the National Council of the Judiciary, churches, religious organizations, even trade unions, and units of local self-government. As far as individual case and individual action is concerned, bodies whose constitutional freedom have been infringed. Additional competences are regulated in Articles 79, 193, and 122 of our Constitution. Everyone whose constitutional freedoms or rights have been infringed has the right to appeal to the tribunal for this judgment on the conformity to the Constitution of statute or another normative act, upon which basis the court of administrative organ has made a final decision on his/her freedoms or rights. Then Article 193, any court may refer a question as to the conformity of a normative act to the Constitution. And then we have this in the process, in the legislative process, possibility when the President may, before signing a bill, refer it to the Constitutional Tribunal. What about the effects of judgment? These effects are strong, I would say. Article 190 stipulated that judgments shall be universally binding and shall be final. They shall be immediately published in the official journal, and the judgment takes effect from the day of this publication. However, and it happens in some cases, the tribunal might specify posterior another date, for example, 6 months or even a year, for the end of binding the force of a normative act. And the judgment stipulating non-conformity to the Constitution of a bill or normative act, on the basis of which a legally effective judgment of a court was issued, then in individual proceedings shall be the basis for the reopening or proceedings, reopening or civil or criminal proceedings. As far as the main features of organizations are concerned, the tribunal consists of 15 judges who, according to the Constitution, should be persons distinguished by their knowledge of law. They are chosen individually by the Parliament, by the lower chamber of Parliament, for the term of 9 years. In the exercising of their office, they shall be independent, and they are governed, they are subject not to the law, not only to the bills, but they are governed only by the Constitution. And additionally, judges shall be provided with an appropriate conditions for their work, and they shall be granted remuneration consistent with the dignity of the office and the scope of their duties, During the term of office, judges shall not belong to a political party, trade union, nor perform public activities that are incompatible with the principles of the independence of the courts and judges. That's, I think, enough about the organization. If you are interested in the details and the supplementary statutory provisions, there are 2 acts. The newest ones come from 2016, and one is focused on organization. The second is focused on the status of judges, and also the translation has been published at Parliament web sites, and this link can be helpful to get to this English text. Our task was to study, to examine cases, and I've chosen to make some limits and to make the effects more comparable. 2-3 branches of law. This is criminal law, civil law, both procedural and substantive, as well as some cases on medical issues. It may be interesting for this conference for the future the matters. So I'd like to mention these topics, these matters that were judged. It was, for example, criminal liability for the public insult of the president, classifying the same action, the same action, both as offense as lower category of misdemeanor. Then criminal liability for non-public insult of a civil servant. Then pre-trial and detention. Right to defense, of course, even in terms for appointing a guardianship to minor in criminal proceedings. As far as civil private law cases are concerned, in those circumstances, in this period of 10 years, we've been given. There were cases on compensation for immovable properties after Second World War, then limitation and the scopes of limitation to ownership to the proprietary rights, then exercising of ownership. Two interesting cases and judgments on copyright, infringement of copyright and compensation for such infringement. Then formal component of cassation, reopening. It is also important and interesting from international perspective, reopening of the domestic proceedings after judgment in a Polish case given by a European Court of Human Rights. Many cases on costs of court procedure and other costs of also administrative procedures, also and mainly from the perspective of rights and access to the court, and also participation in a civil procedure. This case is also interesting from European point of view because the controlled normative act was European regulation on judicial cooperation in civil matters. And medical law, inter alia, slaughter of animals, consent to medical treatment, and important case, medical conscience clause and refusing to perform an act because of this reason. The next part of our work was to analyze in details all those kinds and aspects of interpretation presented both by national constitutional courts as well as by the corresponding European Courts of Human Rights and European Union's Court. And as we know, the issues were grammatical interpretation, logical interpretation, systematic interpretation, historical and subjective, theological ones, then the role of legal literature, of general principles of law and the relationships. The details are presented, of course, in the papers. It's not. I think even that it would not be useful to. We have no time to present all the details, but I'd like to present the summary of this part of our works on methods on interpretation. And as far as grammatical textual interpretation is concerned, the Polish tribunal, it is of course used in practice by Polish constitutional tribunal, both to shape, to discover the constitutional standard, the kind of template, as well as when discussing the real content of the controlled provisions. Not in all cases it is mentioned, but in some cases this is not literally expressly mentioned, but in fact used, in fact applied. And in some other cases, in cases that could be described that clara non sunt interpretanda, the tribunal just use the content, the expression, the meaning, which is clear, without applying or without recalling methods of interpretation. About half of the decision contain reference to the general legal principles, for example, ne bis in idem, nullum crimen sine lege, in dubio pro libertate. What is important, especially in those cases about costs of civil procedure, the principle, the right to court, and the effectiveness of access to court. In European courts judgments, of course, the grammatical interpretation is presented, is important. The fragments of the reasoning are directly linked to the provisions, to the rules that are discussed, examined, and that are the grounds of judging. The ordinary meaning as the way of interpretation, the method of interpretation is of course mentioned in Vienna Convention, and Vienna Convention is a source of law making procedure and actions and operations for the judges of European and international courts and tribunals. So in the cases examined, European Court was focused rather on the, I would say, law in action and practical effects and effectiveness within every branch of law. Then on creating general principles of interpretation, but of course the exception may be the internationally known and understood in a similar way, for example, the principle ne bis in idem. As far as logical interpretation is concerned, the Polish Constitutional Tribunal used in those 30 examined and studied cases the classical logical methods, for example, argumentum a contrario, per analogiam, a maiori ad minus. Yes, a maiori ad minus. I haven't seen the example a minori ad maius. Not always those methods were expressed were directly named, but they were used in reasoning as grounds of the given judgments. Of course, effects of the lex speciali derogat legi generali principle was mentioned by Constitutional Court in several cases, also sometimes without expressing it directly, naming it directly, but this rule was applied in practice. Contextual interpretation. not very often, but, for example, conclusion was drawn from the placement of the constitutional rule or constitutional principle within the full constitution, within the full set of constitutional norms. And for example, an argument can be the placement in the first chapter of constitution. The first chapter of Polish constitution is just called Republic of Poland, and it seems that the placement in this part of constitution may be an argument, for example, when determining the scope of very important article 31 of constitution, saying about individual fundamental rights. Then we have interpretation on the basis of previous jurisprudence of Constitutional Court, of our European courts, and it's obvious that many and every year the next one comes, earlier previous judgments or national or European are quoted, are the in fact basis for a kind of line, jurisprudence line of both tribunals, and we have many examples, detailed examples of such method. As far as international treaties and case law are concerned, Polish Constitutional Tribunal and even more the parties to the proceedings, the kind of, I would even say, kind of mode that in the last years that parties of proceedings, especially in those individual cases when the complaints are written by professional lawyers, those statements of parties or their arguments contain a lot of arguments from European Court of Human Rights. Sometimes it may be observed that even two more, but every individual wants to present as much as can be helpful in gaining a positive for him or her decision of Constitutional Court. And the law, I would finish this part of presentation and my speech. The role of the literature, it's important looking from the Polish perspective. Also by the parties to the procedure, even in the official reasoning by the Constitutional Tribunal, the legal literature is presented. Yes, it's presented either as a strengthening argument to present the real content of the constitutional rule, this template, or in explaining the practical functioning of the questioned provision of statute or law. And this is not seen in these European decisions. Another style of reasoning in this, looking at this element, may be observed in these 60 examined cases. And the conclusions, well, as we know, and as it must have been, because we have chosen 30 national judgments that were connected with the interpretation given earlier by European courts. We can see interaction between jurisdiction of national tribunal and the European ones in creating the content of fundamental standards resulting from principles they are applied by a given institution. We can see that constitutional interpretation may differ and differs from the traditional interpretation of the statutory law. Then the reasoning style and decision template of Polish International Court, I would say that it does not extremely differ from the reasoning style of decisions and judgments and the process of judging by European courts. There are similarities. There is waging of values, building, creating, shaping the model, the standard, the template of fundamental rights, for example. Both Polish tribunal and European ones, they are focused on the practical point of view, focusing on the effects and on this law in action. In all the discussed examples, the subject of interpretation was the normative content of national constitution, as these are control template model standards that were mentioned by me, and the content of the latter was often influenced by the interpretation presented by European Convention and delivered in rulings of European courts. As far as style of reasoning is concerned, I have written that courts present quasi-ex cathedra statements and partly discursive arguments. As far as statistical frequency of the argument types, it's not equal to the practical role. The practical role seems to be much bigger. And the most important arguments, they are mainly based on the previous Polish Constitutional Tribunal rulings, even rulings given under the previous statutes, even rulings given in 90s, for example, they were based on the general rule of Polish Democratic Republika and democratic legal state or state of law. Thank you very much for attention, and thanks for this interesting cooperation.